How does fraud affect the validity of a will? Imagine thinking you have everything in order only to find out later that your will might not be as solid as you believed. Fraud can really shake up the estate planning process and cause big problems. When someone uses deception or tricks to influence how a will is made or changed, it can make the entire document invalid. Courts look closely at whether the will truly reflects the testator's real intentions. If they find fraud was involved, they often declare the whole will or the parts affected by the fraud invalid. That means the estate might not be distributed as the will states. Instead, it could go to an earlier valid will or follow the rules of intestacy, which is how states distribute assets when there is no valid will. Fraud can take different forms. One is fraud in the inducement, which happens when someone lies to the testator about facts that influence their decisions. For example, if a person falsely claims they are the sole heir, the testator might change their will based on that lie. Another form is fraud in the execution, which occurs when the testator is tricked into signing a document without knowing it is a will or not understanding what they are signing. This makes the will invalid because the person did not knowingly agree to it. Forgery is another serious form of fraud. If someone fakes a will or signs the testator's name without permission, the court will reject it outright. Forged wills are illegal and automatically invalid. Undue influence is often linked to fraud, even though it is technically different. It happens when someone manipulates or pressures a vulnerable person to change their will in a way that benefits the influencer. The court can invalidate parts of the will that were affected by undue influence. The key point is that for a will to be valid, it must show the testator's free, informed, and voluntary choices. If fraud is proven, it means those principles were broken. If fraud is suspected, interested parties can challenge the will in probate court. They might present evidence like suspicious signatures, sudden changes, or false statements. If the court finds fraud, it can declare the will invalid. Then, the estate will be distributed based on a previous valid will, or, if none exists, according to state laws. Protecting against fraud is especially important for elderly or vulnerable individuals. Legal safeguards include having witnesses, verifying the testator's capacity, and sometimes involving attorneys or notaries. In the end, fraud undermines the trustworthiness of a will by corrupting the testator's true intentions. When courts find fraud, they often invalidate the affected parts or the entire document to keep estate distribution fair and lawful.